brief, pro present for exam. Okay, good afternoon. Your appearance for the record.
Karen Goldfarb, Your Honor.
Parisa Kiani, Your Honor.
Thank you.
Godfrey Dillard on behalf of Ms. Bothuell.
Thank you.
Sean Patrick Smith on behalf of Mr. Bothuell.
Thank you.
Paris Cadet on behalf of Mr. Bothuell.
Denise Salter on behalf of Mr. Bothuell.
Okay, thank you. This matter was adjourned to 1:30. We're a few minutes off schedule right now. The parties have rested. The people have already put on their case. Defense counsel, we've gone through the office of proof. You're not calling any witnesses because the court did not allow them to call any additional witnesses. And now we're ready for closing arguments. And we will start with you, Ms. Goldfarb. I have another matter that is scheduled to start at 2:15, another at 2:30. So I'm going to ask you, we are not going to, the court has taken copious notes. I've taken the opportunity to read every single note that I've written. I've taken the opportunity to read every piece of paper that has been entered into evidence in this case. And so please, please do not indulge me and think that you must go through every single bit of testimony as well as every piece of paper, because I've already done that. I'm going to say it, I usually tell my kids 3 times before they get it. I have read all of my notes and I have reviewed every piece of paper that has been admitted as evidence in this case. So I do not need anyone to retell the story from the first day until the 8th day. We're not going to do that. So with that said, I am going to really try to give the parties at least 10 minutes to make your closing argument. Ms. Goldfarb, and then we'll go to defense counsel. Only 2 defense counsels will be given a closing argument, one on behalf of each defendant. And then, of course, Ms. Goldfarb, you will have the last bite at the apple. You may proceed.
Thank you, Your Honor. Your Honor, this is a motion to bind over as opposed to a
Yes,
closing
it is.
argument.
I'm sorry. It feels like I've been in a trial because we've been here for 20 days. But I'm sorry, confused.
No, it's. I just want to.
Your motion.
Thank you. And I'm hoping, Your Honor, with what I said just now, to bring this back to the actual evidence and law, because this is a probable cause hearing. Questions of fact that are raised are to be determined by triers of fact. So there was a purpose for me saying what I said. These charges are based not only on the 11 or 12 days that was focused on when we talked about dogs and all that, but on the entire course of conduct between the time that the defendants had custody of this little boy when he was 10 years old until the time he was 12. Your Honor, if a trier of fact chooses to believe that Charlie in those 12 or 11 days eluded everybody, snuck in and out of the house while the defendants lived there, and while the police were going in and out, while the press was outside, so be it. That is a determination to be made by a trier of fact. They want to ignore that there's surveillance and he did not go out of the tunnel, so be it. But there is no evidence. Charlie even had a key. In fact, on June 9th, the defendant, Monique Dillard Bothuell, texted, "I locked Charlie out." June 9th, less than a week before he went missing. And she said she was going back. And on that date, the evidence is Charlie stayed where he was supposed to be, just like he had done, and waited for her to come back and let him in the house. Charlie started the confinement in their home when he was with them at the time he was 10. And during that time, he endured years of abuse and torture. He ended up, the evidence shows us, stuck in their basement, scared to even come forward when the police were there. And, Your Honor, he may look like a teenager now, and they may want to call him a teenager, even though he was not, at that time, a teenager, and he certainly wasn't when he was 10 years old. The defense wants to blame the child for it all. Call him a bad kid. Say he was out to kill his family with some common household items, and that he was, as Mr. Dillard continually said, a firebug. Somehow, I guess they think that's highly relevant. But I submit to Your Honor that it does not prove anything. It doesn't prove that Charlie made anything up. What I do also submit to Your Honor is that if that's true, then why was he left alone day after day in their home, even after he supposedly tried to kill the family or set fires? Because that's the evidence, that they left him there, confined him there, had him, and went out all day, and he stayed because that's what he was supposed to do. And we know that Monique Dillard Bothuell texted on June 10th, after he was supposedly trying to kill them all, that he had messed up, and she forgot to report it. Forgot to report that he had messed up on some dishwashing chore. Your Honor, no matter how horrible this child was in their eyes, no matter how firmly they believe it, it does not give them permission to abuse and torture and bully Charlie Bothuell V. The question of fact before Your Honor, is, did he make this all up in order to go home with his mother, or was he in fact an abused and tortured child? Was this something they did to get rid of his ass, as the defendant Charlie Bothuell IV said he wanted to do in his text? Was it something that she did because she despised this child and referred to him as a moron? Because that's the evidence, Your Honor. That's the actual evidence in this trial. We began with 3 days of Dr. Nazar. She's an expert. She's board certified in pediatrics and board certified in child abuse in the United States of America. And she is the chief of the child protection team at Children's Hospital of Michigan. And she has been at Children's Hospital of Michigan for 15 years. Dr. Nazar looked at the pictures that Your Honor has, and those were pictures taken when he came out, when he was found. He was 12. She testified that the scars on his buttocks were consistent with inflicted injuries, that, as Charlie described. She testified that the scar on his chest was consistent with an inflicted injury, a pattern injury, a pole, that pole driven into his chest. And the defendants themselves, both of them, admitted that Charlie Bothuell IV used that pole that has been entered into evidence to beat this child from the time he was 10 to 12 years old. On the date that he was found, Charlie's eczema was severe. The hospital suspected that he had scabies, and he had lost 25 pounds over 2 years. You heard Dr. Nazar testify that it is not healthy for a child to lose weight in that way. They're supposed to grow into their weight. The defense attorneys continuously question about Charlie's last known pediatric appointment with Dr. Mosby. And Dr. Nazar did look at those records and testified to the recommendations. First of all, the appointment was when he was 10. It was in December of 2011. And he was advised to eat healthy, to limit his snacks, and exercise 20 minutes a day, which for a child means riding a bike, playing with a friend, doing a team sport. But the defendants interpreted that to enforce exercise routine twice daily on this young boy. Dr. Nazar concluded and testified, and that is a question of fact. To whether her testimony is credible is a question of fact. She testified he was abused based on his appearance and the scars on his body, and on the life he described living since he was 10. It was her medical opinion that Charlie was tortured. Why did she make that diagnosis, that he was an abused and tortured child? Because of the systematic routine, in part, of this routine of indoor isolated exercise imposed on him at least twice daily. She said that was abuse. And Charlie testified that it was much more than just the elliptical. Hundreds of sit-ups, push-ups, jumping jacks, and bicep curls. And whether Charlie enjoyed the results, liked that he looked better, is irrelevant. People can come out of the hospital and like that they're thinner. It does not make it healthy. It does not make it any less abusive. It does not make it any less assaultive. And we know from the defendant's statements that this was imposed. We know from the statement of Monique Dillard Bothell and Charlie Bothell IV, but hers in particular, she says that Charlie ran away because, and this is her word, not mine, an infraction, she calls it, because, and her word, shortchange his workout regime. That word infraction is a word used by corrections officers when people don't behave and do what they're imposed, do what's imposed upon them. Essentially, that's what the kind of life Charlie lived, a prisoner in the home. And when he was there, and he was there most of the time, an isolated existence where he did chores and workouts and some kind of schoolwork from computer printouts. In the evening, his every move was monitored, and there are text messages going back and forth that were submitted to Your Honor about when he went to the bathroom. Everything was monitored and reported by Monique Dillard Bothell, who was monitoring and reporting to the warden. And yes, the information is that he was taken out to eat a few times. But by the way, let me suggest, Your Honor, that going out to eat and being served food does not constitute socialization for a 10-year-old, an 11-year-old, or a 12-year-old. There is evidence that he visited some family occasionally, but that does not take away from the many, many, many months of isolation, deprivation, lack of socialization. 1 month out of 24, even 2 months out of 24, does not change what they imposed on Charlie Bothell V. He was routinely hit with that pipe, subjected to standing with his arms in some kind of routine, arms in the air, some kind of routine they called reach for achievement, while he begged to stop and shook and cried. And they call this routine of deprivation, lack of socialization, beatings, and enforced exercise, homeschooling. You can look at the pictures. There is not one item in that home consistent with any real attempt to educate the child. No desk, not a toy or a block or anything to do a science project or do an illustration. Computer printouts are not schooling. No. Even this young man's bed was taken away. Homeschooling is not an excuse for isolation, deprivation, abuse, and torture. Psychologically, he was threatened. Charlie Bothell IV drove him around, saying he was going to drop him off in some place. Nobody would care about him. Nobody would want him. Nobody would know where he was, Haiti or Utah. And he was terrorized. Of course, we as adults know that some preteen with no record of schooling for 2 years and no pediatrician appointments for 2 years is not going anywhere. But Charlie was terrorized, psychologically abused, and it was all part of the torture that he endured. On June 14th, the defendants claimed Charlie ran away. The reason he ran away, they say, is because he was in trouble for his infraction of going to the bathroom during his workout. And because they had decided he really didn't have to go to the bathroom. But Charlie told you, just like he told the doctors, just like he said at Kids Talk, that he did not run away. Monique Dillard Bothell put him down there and told him to stay. And I submit to you, Your Honor, that behavior that Charlie testified to is completely consistent with her attitude of reporting every move, calling him names, accusing of a murder for using a wrong sponge, and mocking him instead of getting him help when he made a suicide attempt. They both showed nothing but disdain, hatred, and a desire to get rid of him or have him in trouble. They both did it. They want to blame Charlie. He could have left. Again, he was a helpless 10-year-old, 11-year-old, 12-year-old. No resources, and he tried once, and he was returned, and his life got worse. And the young man you saw on the stand was the product of what they did to him. The psychological abuse of a child who was treated the way he had been treated over his young childhood. We want to blame the police for not finding him. This was their home. This was a place in their home. It was their iPad, their computer, their blanket, their pillow, their food that supposedly was missing or used and never reported to the police. There's a reason for that. Because they knew exactly where he was. They did it just as Charlie said. One of the most disgusting parts of this defense, Your Honor, is to blame the police for having some compassion, caring about Charlie, getting food for a hungry child, giving him a hug. The defense would like everyone to treat Charlie like they have trying to portray him as some disgusting, bad person who deserves the torture they inflicted on him. And I submit to you that that this was nothing more than psychological and physical abuse. The people have shown the elements. Child abuse second, over the course of 2 years, they isolated and deprived him, kept him in home confinement when he was with them, assaulted, and imposed the extreme exercise routine. He had no socialization when he was with them, was mentally bullied, told he was going to be left somewhere, and then, as a final assault, confined him to an even smaller cell in their home over 11 days, where he had even less access to food, bathroom, hygiene facilities, not to mention socialization. The people, Your Honor, have proven for probable cause purposes that the defendants did multiple acts that were cruel, and they did those acts intentionally. The defendants did inflict serious physical and mental pain on Charlie Bothuell V. He was a child who was in their custody and control, and for probable cause purposes, the people have proven child abuse in the second degree. Torture. The defendants exercised physical control over Charlie Bothuell V. They restricted his movements. They confined him to the house and then to the basement. And while they had physical control and custody, they inflicted great physical injury and mental pain and suffering. And restriction, Your Honor, does not mean having to be tied up. Psychological restriction, fear, terror is also control. And one of the choices as to serious physical injuries under the tortured statutes includes severe cuts. Charlie described being beaten with that pipe on his butt and his feet until he bled, until he couldn't move and had trouble walking. He described having that pipe driven into his chest. That constitutes severe cuts and was inflicted on him multiple times. The defendant's entire scheme of deprivation, isolation, threats, and lack of socialization did in fact cause a disruption in Charlie's mental functions. He did become suicidal, and he was so terrorized that even when the police were looking for him, he did not speak up, he did not present himself, and he continued to stay in that little space in the basement where the defendants confined him. This is a child. He speaks like a child. His memory is like a child. His hesitancy is that of a child. But when he was found, he was so terrorized that his first question was, where is my dad? Is he here? Because even surrounded by police, he was terrified of his father. Those are all changes in mental functioning, in the way he thinks, and the way he acts, and in the physical abuse that constitutes torture. And the people have shown for probable cause purposes that Charlie Bothuell V was abused. Thank you, Your Honor.
Thank you. Who's first for the defendant?
Good afternoon, Judge.
Good afternoon.
Good. Judge, I'm glad we have a statute so it sets forth specific elements that need to be proven or at least established by some level of evidence for the prosecution. And I know the court has had an opportunity to look at the torture statute 750-85 as well. Yeah. So I know the court is aware of the specific requirements.
Yes.
Specific intent crime, causation crime, cruel and unusual punishment. Have the people established that Bothuell had the specific intent to torture? Reader statement. Breakfast in the morning, therapy for several hours, house cleaning, and dinner at night. A stepmother burdened by the daily routine caring for an autistic child and newborn. A routine that had her at therapy for most of the day. A routine confirmed by the alleged victim himself. A spouse, a housewife, giving deference to the biological father on the management and punishment of his son, not hers. Simply reporting the son's compliance with his and biological mother's directives. Punishments meted out by the father and biological mother, not the stepmother. The text message exhibits indicate that she had to ask the father how many revolutions was the child to do on the elliptical machine the night of his disappearance. When she accidentally locked him out of the house that Madam Prosecutor talked about, clear that she didn't finish it, she came back and said it was an accident and let him back in. Now, let me turn to what I think is what is really significant. What weight should the court give to the child expert, Dr. Nazar? The child expert is a classic example where the court is obligated to act as a gatekeeper. The jurisprudence consistently cautions against over-reliance on the opinions of experts. The expert is not the trier of fact or the determiner of probable cause. In my opinion, a court should give very little weight to the child expert in this case based on the totality of the testimony. And let me tell you why. What was her methodology? She did not read the police reports. She did not read the statements of the witnesses. She did not interview the parents. The psychiatric illness of the child, no effect on her opinion. Did not look at Dr. Mosby's records in detail. The alleged victim's primary care doctor was not aware that he was diagnosed with ADH, not aware that the alleged victim had assaulted other children or hostility to authority figures, teachers, no effect on her opinion. The fact that he had lied to police officers, no effect on her opinion, and her review of the medical records did not include any physical or mental injuries arising to the standard of torture as set forth in the statute. Her medical definition of child abuse included any inflicted injury whatsoever. She went on to say that it included many examples. It was a standard far less than the standard legal definition of torture set forth in the statute. She did not limit it to great bodily injury, an impairment of bodily function, extreme, severe, serious, or substantial injuries. Consequently, the court cannot apply this medical standard in this case. And let's go further on her methodology. No personal interview of the child. no individual examination of the child. What good is the opinion of a person who is an acknowledged expert with fantastic degrees, experience, and allocates from his or her colleagues if his or her opinion is based on false, inadequate, questionable information, or mere speculation? The court must act as the gatekeeper. In this case, the expert's opinion was based solely on hearsay medical record disclosures made by the child alone. And guess what? These basic facts were disputed by the alleged victim himself. Most of them lies, if not fabrications. Did Miss Bothuell beat him with a pipe on his buttocks? No. Was he confined to the basement for the duration of the time he was missing? No. Was he isolated in the basement for 10 days, the evidence established? No. There was no psychological maltreatment, no social isolation. The court can determine that from the young child's testimony itself. He was not homeschooled by Miss Bothuell. There was no testimony that the child was subject to constant threats to his life by Miss Bothuell. Miss Bothuell consoled him when he considered suicide, if you believe him, indicating that someone did care for him, namely Miss Bothuell. Miss Bothuell did not deprive him of food. He had access for food. He even testified she fed him while he was in the basement, if you believe him. Miss Bothuell did not deny him the use of the bathroom. He did not hold his bowel movements for 10 days. The child said he used the bathroom upstairs for bowel movements from his own testimony. Total inconsistent facts with the disclosure that the child expert was basing its opinion on. Based on the totality of his testimony, being simply afraid or scared of Miss Bothuell is not sufficient level of evidence to establish torture or child abuse. He did not lay out any consistent or lengthy details to facts to justify his fear. He simply said he was afraid of her. The alleged victim was never barricaded in the basement. Unless you reject the total professionalism of the sweep teams for dangerous people during the search warrants, he was not in the basement. You'd have to reject all of the sweep testimony from the prior group of police officers that went in before the evidence technician whose sole purpose was to sweep for dangerous people. You have to reject all of that to find that he was still in the basement. You even had Sergeant Passmark said that he had concluded today that he had ruled out that he was in the house. Maybe he was at the Martin Luther King apartments playing basketball, as some of the witnesses testified. But Sergeant Ducker just said that they were not credible, but he never explained to the court why he felt they were not credible. The stepmother did not cause him, this is causation crime, did not cause him to hide, repeat, hide behind a freestanding 3-foot barrel. He did it on his own free will. You heard the FBI agent say that there was that pallet area, but when he found him, the boy was standing behind a 3 or 4 foot barrel hiding. Not once have you heard a witness say the stepmother denied him food. He went upstairs and downstairs whenever he wanted to eat, whenever he wanted to hang out, when nobody was present in the home. But guess what? He did not do that when the police were there. He did not come upstairs when the FBI was there. He did not come upstairs when the evidence teams were present. You have not heard one witness say the stepmother isolated him. He gave no explanation whatsoever for why he did not just walk out the front door, walk out the back door, walk out the basement to escape his so-called prison of isolation. He gave the court absolutely no explanation for that. If he peed in the basement in the drain, he did it because he wanted to. Another falsity in the disclosure. He indicated that he went upstairs on several occasions to use the bathroom. There was no denial of bowel movements for 10 days that Dr. Nazer justified her ruling on, her opinion on. The witness himself said that he went upstairs and used the bowel. passed his bowels in the upstairs bathroom. Even if you believe, and I'm saying that you should believe him, but even if you believe that Miss Bothuell told him to go down in the basement, you know, for some old school parents, that's called the timeout zone until you follow the rules. And for the new school, it's sometimes called the time in zone. And the bottom line is, what injuries resulted? The statute requires causation of injuries. What injury was caused? What verified mental injury did he suffer? The statute talks about alteration of mental function. What testimony did the court have that demonstrated that? What testimony of injury, poisoning, serious burns, severe cuts, multiple punctures? No evidence. The court has to look at the statute and see what the statute requires, not this conjecture that we've been healing. What medical evidence testimony we have from a psychiatrist that there was severe, extreme, serious, or substantial mental injury caused by the stepmother? No medical expert testimony of any severe, extreme, serious, substantial, physical injury whatsoever caused directly by the stepmother. Causation statute. What? Absolutely no evidence of any brutal, inhuman, sadistic, or tormented treatment caused by the stepmother. Absolutely no evidence of denial of food, clothing, or shelter directly by the stepmother. Now, the prosecution wants to make some hay out of the fact that there may have been some allegation by the young man that she may have punched him or an isolated choke. But when you question the witness about that, he never explained when, why, how, what the context of when that happened. Did it happen a year ago? Did it happen a month ago? When did it happen? The statute requires that the threat must be imminent. That's what the statute requires. Where is the proof that it was imminent? A child living with a stepmother on and off for several years. What woman has not touched or grabbed a man-child who has disciplinary issues? What woman in a fit of anger or frustration has not said, "I'll kill you if you don't mind," not literally meaning it? I've heard it. And I know there's lots of folks out here that heard the parents say that, not meeting it. There's no indication that she had any intent to do that at the time she said it. No holding of any weapon, no gun, no knife, no striking the child, absolutely nothing. At best, an indication of anger and frustration for the child not following instructions. What child is not afraid of most parents? What child is not afraid of most parents?
My kids are not afraid of me.
Well, Judge, that may be your belief. That may be your belief, okay? May be your belief. But what I'm saying to you is that the child's fear of a parent is not evidence of extreme, severe, substantial, serious physical or mental injury. It is an emotion, sometimes justified, sometimes not. What we have here in conclusion, Judge, we have a poor and childish judgment by the child, playing the game of hide and seek. That's what he was doing, with horrendous and catastrophic consequences for the stepmother and his sibling. She is guilty of guilt by association, in the wrong place at the wrong time, married to a man struggling to raise his dysfunctional son. The facts do not justify or confirm the so-called fairy tale bias of the wicked stepmother. I do not think that evidence has shown this. Just imagine the briefness of the exam that this court had granted my severance in terms of the testimony that actually relates to Miss Bothuell. She's already been punished, Judge. Unjustified punishment has already been meted out to the stepmother. separation from her biological children for one long, stressful year. The confusion, anxiety, the antidepressant medication and suffering by the autistic child and newborn.
Hold on, you can't talk at the same time.
And newborn.
Counsel, you're off in an area that
Well,
has nothing to do with any of the facts
I
that have been
understand.
placed on this record, so please.
Well,
Let's stick with the facts, because I already said I was limited.
I'm sure.
And now you're in an area that has nothing to do with any of the testimony that's been placed on this record.
And in all fairness, I thought Madam Prosecutor went in some areas as well, but I didn't interrupt her.
Counsel, please continue.
Thank you. Where is Mommy? The prosecution recognized there was no injuries to the child, so they charged second degree as a fallback net. But the defects that you saw in the torture charge are also found in the second degree charge. There's no showing, look at the second degree statute, no showing of an admission by the stepmother caused any serious injury to this child. The statute requires causation. There was no showing that a reckless act of the stepmother caused serious injury to the child. The statute requires causation. There was no showing that the actions of the stepmother on her face were likely to cause serious injury to the child. Therefore, whether there's harm or not is irrelevant. And there was absolutely no showing that the actions of the stepmother were cruel, that they were brutal, inhumane, sadistic, or that which torments. There's no evidence of brain damage, a skull or a bone fracture, bleeding, dislocation, sprains, poisoning, burning, scalding, or severe cuts caused by the stepmother of the child. Where did I get that? From the statute. There was no evidence of a visibly demonstrated manifestation of a substantial disorder of thought or mood that significantly impaired the child's judgment, behavior, capacity, or ability to recognize reality, or ability to cope with ordinary demands of life caused by the stepmother to the child. Where did I get it? The statute requires it. Causation, medical testimony to substantiate it. There is no substantial relevant question of fact as to plausible cause to be balanced or weighed regarding the stepmother. To find so would be to find so against the biological mother. There's testimony that she whipped the boy as well. There's no testimony that the stepmother whipped the boy. I asked the court not to bind over Ms. Monique Bothuell. I know that this has been a long preliminary exam. I know that there has been a lot of testimony, a lot of back and forth, but I am asking the court, if you really look at the totality of it, the facts that we can relate specifically to Ms. Bothuell, there has been no showing consistent with the statute that there was torture or second-degree child abuse, and therefore I asked the court not to bind her over.
Thank you. On behalf of Ms. Boswell,
Judge, I don't think there's any time left, so I'm just going to,
your argument.
Judge,
I'm sorry.
thanks. I appreciate the fact that you paid attention. I know that you said that you've read everything. I don't want to go over everything that Mr. Diller just said, but there are some things within the statutes themselves I'd like to talk about. Before I talk about that, Dr. Nazer, in my opinion, just as in Mr. Diller's, I adopt everything he said about Dr. Nazer. I'd only like to add one thing, and that is I asked her to imagine Charlie walking in that door and coming in and standing in front of us all and saying, "I'm so sorry. I made it all up." And then I looked at her and I asked her, "Would you change your opinion if you had come into this courtroom right now and looked at us and told us, 'I'm sorry, I made it all up'?" And her answer was, no. Now, an expert who can't even honestly and being unbiased and look at the situation and deal with a hypothetical like that is not somebody that can be trusted to give an opinion in this case. Everything Mr. Dillard said is absolutely true. She did not do any of the things that anybody would expect of an expert. Not interviewing the child, not reviewing the police reports, not dealing with the inconsistencies. And another thing nobody ever brought up is the fact that 2 years prior to this happening, Charlie Bothuell V ran away from home and was caught by the police. And the police said, "Mr. Bothuell, what's going on? Where have you been?" And he looked at them in their eyes. There was 2 officers. And he said, "I've been held captive by a man with gray hair in a tunnel." And the kid flat out lied, made up a story that is so bizarrely close to the story he made up here. I hope that the court does not let that pass. Because to believe any of this, you have to believe Charlie. And I submit to the court that you can't even believe Charlie. I mean, there's nothing credible about what he said. He initially told the police that he didn't go to the bathroom, number 2, which is poop, for 11 days. He told all the people at the hospital that. And then he comes to court and he talks about how I went upstairs freely, anytime I wanted, anytime anybody left. And we used the bathroom. And I ate food. He told people that he didn't have any food. He only had some scraps downstairs. And that was his initial statements. But then when he came here, he changed the story again. Now, if you look closely at the medical reports you have, it'll show where he tells the doctors exactly that. I didn't go to the bathroom for 11 days, and the doctors analyzed that and checked his stomach and his abdomen. They found nothing strange about his body. There was nothing about him related to, like the prosecutor saying he was tortured, he was isolated, he was in the basement, he was in poor condition. Poor condition? I mean, come on. He walks up the steps. They don't call 911. They don't get the ambulances over there. The police don't do anything like that. They give him a hug, say, "Oh, poor Charlie, let's sit down." And he even says the prosecutor sits down and starts talking to him. Nobody calls an ambulance at all. Not even this prosecutor called 911 to get him to the hospital immediately, because none of them saw any signs of distress. Why didn't they see any signs of distress? Because he was not really in the basement for 11 days. It's quite clear that the police went down there and basically turned the place upside down, looking for microscopic evidence. There were dogs that were down there. There were multiple visits. There were people there round the clock searching that house. It even got to the point that the officer in charge said he was so convinced by the prior searches when he became the officer in charge, he ruled out the fact that any part of the interior of the house had anything to do with Charlie in it. And then you throw in the tracking dog that they brought there to find Charlie, and the dog immediately picks up a scent, and where does it go? It doesn't go down in the basement. It goes right out the front door, right up the street, right around the corner. I mean, the tracking dog doesn't have any bias. The tracking dog is objective. The tracking dog just follows the scent. The tracking dog is what they used. And the tracking dog took Charlie out of the house after the fact. The scents are not there for a long time. We all know that. We're in the business. Criminal law, we all know what the rules are. Tracking...
Objection, Your Honor. This is facts that are not uncontested.
Placed on the record, Mr. Smith. Please continue.
The prosecutor said that this case disgusts her, that this is disgusting, the way we're portraying little Charlie. We're not trying to be disgusting. We're trying to just tell the reality of a boy who's a broken boy, who's caught between wanting to live with his biological mother and being placed with his biological father. When he's placed with his biological father, his grades go up by his own testimony. His health gets better by his own testimony. The exercise that he's been asked to do makes him more fit. He used the words, "I feel proud of my new physique. I was happy the way people were treating me." I asked him, did this exercise help you? Yes, it helped me. It made him feel strong. It made him feel better. It made him feel positive about himself. And then she tries to tell, the prosecutor gets the audacity to try to compare the before Charlie and the Charlie that came here. The Charlie that came here is a byproduct of the prosecution leading him down the path where he has to falsely accuse his stepmother and his father of abuse, of torture, because that never happened. I mean, this kid that came here could barely answer the questions. Why was he so coherent when he was first picked up and placed in the interview rooms on 2 different occasions? Why was he so coherent and clear and decisive and positive then, and now that he's living back with his mother, and he's not in control of his weight, and he's lost composure of his life, as he's sitting there looking like the way he looked and acting like the way he acted. Because everything that happened at the house was positive. You know, are parents allowed to discipline? If you look closely at the statute, number 9, of child abuse, it says, this section does not prohibit a parent or guardian or a person permitted by law or authorized by a parent or guardian from taking steps to reasonably discipline their child, including use of reasonable force. So I guess for that count, the question is reasonable force. But as to the child abuse second degree, none of that applies. I mean, the only thing the prosecutor could point to, because again, like Mr. Dillard said, there's no omission on behalf of Mr. Bothuell. That doesn't apply whatsoever. In order to find that there was second degree, there would have to be an omission or reckless act. It would have to cause serious physical harm or serious mental harm, which, of course, you said you've already looked over at. Now, in order to deal with that, in order to find there's these issues, you would have to go to Section B of the statute. And Section B of the statute talks about a person knowing or intentionally committing an act likely to cause serious physical or mental harm to a child regardless of whether harm results. The reason they say regardless of whether harm results is because the first leg of it, the omission, has to have actual harm. And to have actual harm, there has to be serious physical harm, which, as Mr. Dillard wisely pointed out, has to be, it's not limited to, but they use words like brain damage, skull or bone fracture, subdermal hemorrhaging or hematoma, dislocation, sprains, internal injuries, poisoning, scalding, burning, or severe cuts. None of that is in place. And as to the severe cuts, if you look closely at the medical records that are entered by the prosecution, when Charlie first goes to the hospital and they ask him about that thing on his chest, that wound that the prosecutor says is caused by the pipe, he says, I'm not sure how that happened. I mean, how could you possibly have two diametrically opposed stories like that? Now, Your Honor, the reality of it is I don't think anything should be bound over on child abuse whatsoever. There are secondary charges like third and fourth degree. They're both misdemeanors. They talk about a person's omission or reckless act causing physical harm to the child. But again, a reckless act would have to be using too much force. Is that where we're headed right here? Because if that's the case, this is a one-year misdemeanor and doesn't get bound over, it gets remanded back to district court. That's the only thing even close, and it still doesn't meet the standards because a parent has a right to use reasonable discipline to discipline a child. This is not systematic. This is not a systematic situation where a child's getting beaten repeatedly over and over again. He never testified to that. I mean, if you just use the child's own words, Charlie, never testified to any of that. And to torture, I'm just going to briefly hit on torture, Judge, because if you believe Charlie, and you have to think about the psychology of this, if you believe Charlie, he blames the whole basement thing on the stepmom. According to Charlie, his dad never knew that he was placed down in the basement. According to Charlie, he saw his dad looking for him in the basement with a light. And he said he was happy that his father was looking for him. But he knew that his dad didn't know where he was because he knew that his stepmom didn't say anything about it. There was no evidence to suggest that from Charlie or anybody else suggests that Mr. Bothuell placed the child, ordered the child, did anything to put the child in the basement. Which means all the 11 days that Charlie was supposedly in the basement, which again I don't think he was, but if you believe that, all those 11 days are not attributed whatsoever to the dad. Which means all the torture elements of this case, as it relates to the dad, are absolutely out the window. But just on the outside chance you're thinking that there might be some claim of torture here related to Mr. Bothuell, to have torture you have to have great bodily injury. And you have to have, as he said, causation. One moment, Your Honor. You have to have then next, you have to have cruel or extreme, things that are cruel or extreme physical or mental pain and suffering. The prosecutor already pegged it that she was going with the mental pain and suffering. So I'm going to take her at her word that that's where she's headed. She said there's mental pain and suffering. It has to be cruel or extreme. The mental pain and suffering has to be a mental injury resulting in substantial alteration or of a mental functioning that is manifested in a visible, demonstrable manner. The words visible, demonstrable manner do not apply in this particular case. I think she's trying to say, the prosecutor's trying to say that because he says he tried to commit suicide, and remember, his suicide was he put a butter knife to his wrist and left no visible marks. He came up and showed you, and he tried to claim there was a mark on his wrist, but there wasn't. Now, if you want to go the other route with torture, you have to find great bodily injury, which she didn't talk about, but that's a serious impairment to body function. We don't have that. Serious burn, we don't have that. Scalding, we don't have that. Serious cuts, we don't have that. Multiple puncture wounds, we don't have that either. Poisoning, internal injury, none of that as well. You know, I'm dumbfounded they even brought the charges of torture against my client. And I'm asking you, court, to think about all the people you've met in your life that talk out of both sides of their mouths. I've met many. I know a lot of people like that. I know people who tell you something one day, and the next day you ask them the same thing, and they tell you something completely different. And for me, it reminds me of a babysitter that once came. I asked her where she went to college, and she told me one thing. She said, I went to the University of Michigan. And then 2 days later, when she came back, my wife asked the same question. She gave me a different college. It only took one time for that person to lie to us, for us to lose trust in them, for us not to believe in them. And I'm asking you, when you're judging what little Charlie Bothuell did in this case, how many times he's talked out of both sides of his mouth, how many times he's basically flat out lied, and how he's lied to people in the past, how he's made things up in the past, how he started fires, how he's gotten kicked out of schools, how he's stolen in schools, how he treated the teachers to the point that they wanted him to leave. Think about all of that and then ask yourself, can I trust anything that this kid says? Because you can judge credibility in a preliminary exam. The law allows you to take that into account. I'm asking you to take that into account and not bind Mr. Bothuell over on torture or on child abuse. Thank you, Judge.
Thank you. So far,
You know, there's some things that are pretty astounding, and to me, suggesting that he didn't make a good suicide attempt is pretty astounding, and is exactly what the defendants did as they taunted him. Said, oh, and she said, I know where the sharp knives are. This, Your Honor, was a 12-year-old, 13-year-old when he testified before you, who came in here, had to face the parents who did not want him, who tortured him, who abused him, and treated him as a captive for the 2 years. And so, yeah, I think that his demeanor would be somewhat different, and doesn't mean he made it up. It means he is a child. It means that this is difficult, that there's cameras, there's a court. It doesn't make him not a credible person. The big discrepancy they both counsel point out is the number of bowel movements that he said he had a year ago as opposed to what he remembered having now that he testified. People can make mistakes. Saying you don't remember doesn't mean you're a liar. And believe me, Your Honor, if I was going to coach, if I was going to give him a script, and if I was going to tell him what to say, I certainly would have done a much better job. What we had is a child doing what he can do under the very difficult circumstances right here. And Mr. Dillard's suggestion, well, he had a psychiatric illness, he was badly behaved, the defense suggests, does not provide them an excuse for the injuries psychological and physical, that they chose to inflict on him. They are aiders and abettors. She was reporting him up until the very last time, when she finally got rid of him. Finally. What she wanted. To the person who was imposing the torture, they were both engaged in this psychological abuse, and they were joined together in their acts. Your Honor, I will leave it to the court, because I know what we charged, which was that their acts were cruel over an extended period of time. They did intentionally and knowingly commit acts that were likely to cause serious physical harms, that were cruel, and that was when they systematically imposed this structure on this child of isolation and deprivation and discipline involving these enforced exercises and beatings with a pipe. I already explained the people's theory with torture, and it includes mental harm that was manifested when the child is scared to even say where he is. And you know, it is a question of fact whether there was a good search, but the police told you, Officer Dillon and Sergeant Ducker, that the boxes were not moved. He was behind them. So they can pretend, they can say there's evidence of this thorough search, but the evidence from the witness stand was that those boxes were not moved before. And there is no evidence that Charlie was managed to get in and out of the house and elude the police and the press and the parents during that period of time. There's no evidence of it. Your Honor, this is a probable cause hearing once again, and for probable cause purposes, the people have shown that over a 2-year course of conduct, these defendants together imposed torture and child abuse in the second degree
Judge,
over a period.
I'm going to object. The information does not have a end date and an opening date and an end date. It only has one date. The information says 6/14/2014. So unless they're going to move to amend the information, I don't know what she's talking about this 2-year thing for.
Well, I was hoping somebody was going to raise that point, and
Well,
I'm not serving as defense counsel, I certainly was not going to do it.
I object. We just wanted her to pause before we could make that objection, Judge.
You all never waited for a call.
Well, Your Honor, yes, I would move to amend it, and I think it's very clear from the people's charges in the information, did knowingly or intentionally commit an act likely to cause serious physical or mental harm, and that was cruel to a child, systematically beating and imposing a regime. Those are the charges. That's what the information states. That's what it states in the torture as well. So if the date itself wasn't correct, the charges are exactly what the people have proven.
Your Honor, I would.
And I would move to amend to reflect from December of 2011 through June of 2014. But they have plenty of notice based on the charges as they are in the information that this was a course of conduct that the people charged over a period of time.
I'll give you an opportunity to respond to the amendment of the charge.
Yes. The people relied upon the testimony of Dr. Nazar for the torture and child abuse case. And the testimony of Dr. Nazar was basically based on the disclosures given by the child on the day in which he was taken to the hospital. Those disclosures did not relate to any 2-year period. It related to those events of that 10 days and the 14.
I reviewed all of the medical records that Dr. Nazar indicated that she reviewed for purposes It was given to me as an exhibit during the preliminary examination, and so I'm going to allow the complaint to be amended. Were you finished with your last?
Judge, just for the record, we're going to object to the amendment, but
Yeah.
we understand your ruling.
So noted.
No, Your Honor, again, this is a probable cause hearing, for probable cause purposes, based on the testimony of Dr. Nazar, the statements of the defendants that corroborate much of what Charlie said, and based on Charlie's testimony and the evidence on his body, I would ask for bind over. Thank you.
Okay, thank you. I am ready to make my ruling. I've heard all of the testimony, I believe, 8 days of the testimony. I've also had the opportunity to review all of the exhibits that were admitted on behalf of the people as well as on behalf of the defendant. And with respect to, I want to start with the testimony of Dr. Nazar, and I did allow the people to amend their complaint. The doctor testified on direct examination as well as cross-examination that she made her determination that the child had been tortured, and she used the word tortured, even though it's not a legal term. She said that it was based on her review of the medical history of the child, which has been determined by this court to be incomplete. She said she made her determination based on the medical records of the child, which has been determined by this court that those records were incomplete. She also indicated that she made her determination based on interviews, and the interviews were kids talk, FBI, different interviews, and just on some of the cross-examination of Charlie himself, this court finds that those interviews were inconsistent. The doctor also testified that she made her recommendation based on photos of the child. The doctor indicated that in order to determine whether or not a child is abused or tortured, as she indicated, she looked at the fact that Charlie had been isolated. She specifically stated that Charlie had no friends, no girlfriend, and that he was homeschooled. However, the testimony on the record by Charlie himself indicates the total opposite. Charlie testified that he did spend weekends with his mother, that he did have the opportunity to hang out with his cousins, that he did go to the park on occasion, that he did leave the state and spend time with his grandfather in another state. He testified in one of his interviews that he had, anytime he went away from the house on Nicolette, that it was never unmonitored by the defendant. Well, Charlie's testimony on the stand contradicted that interview because he did go to his mother and to his cousins and to other places, and he was not always accompanied by the defendant. During the examination, the doctor said she made her decision based on the fact that he was isolated from what children do. However, it was clearly brought out on the record, as far as this court is concerned, that Charlie had access to social media. Now, he denied ever using it, and then he said, well, he did, but the specific posts that he was cross-examined on, he said he did not post those things, but he never denied having the social media account, which goes against the conclusion of the doctor that Charlie was isolated. The doctor also indicated that Charlie was homeschooled, which happens to be a part of why she ruled that, or she thought that he had been isolated. And it's clear from the record, from Charlie himself, that he was homeschooled. He was having problems in school. He was not making the grade. He was having behavioral issues. And so the decision was made to homeschool. And unless the people are going to find that the state somehow failed, who's responsible for monitoring homeschool, and I didn't see the state, anybody from the state indicated as a defendant in this matter, I certainly can't conclude that the fact that the child was homeschooled is a part of isolation for some cruel or some kind of cruel intention to torture this child. The doctor went on to state that she made her ruling or her determination based on the fact that Charlie had been deprived of water and food. However, during his testimony, Charlie indicated at first, he said that defendant Monique Bothuell, brought him food in the basement. He later testified that he would actually sneak upstairs and get food. And then in his FBI interview, he said that Monique Bothuell never brought him any food. He totally did not tell the truth. It's more than just a child being confused and being afraid. They are totally inconsistent be important to anyone else. It was important to this court because Mr. Bothuell, Charlie Bothuell, the complaining witness, got on this stand and testified that he would sneak upstairs and use the bathroom. Again, this is more than just a child forgetting something, being nervous, totally inconsistent story, and I could not believe what he said. The doctor also testified that she made her recommendation of torture because of the excessive exercise and weight loss. However, on cross-examination, Dr. Nazar, who never had a conversation with Charlie, who never examined Charlie, who did not have the complete medical history, did not have the complete medical records, knew about the inconsistent statements in his interviews, assuming that she did. I could never really get clear on whether or not she reviewed all of the interviews, but she never talked to Charlie. And on cross-examination, she indicated that it could have been that he did not have enough food, or it could have been that it was too much exercise that could account for the 25-pound weight loss that the child had sustained over a 2-year period. Now, I bring that point up because when the doctor says, well, it could have been the lack of food, again, the hospital who examined the child at the time that he was brought in, the records say, well nourished. In addition, Dr. Nazar, on cross-examination, admitted that she never reviewed the records of Dr. Mosby, who had examined this child with respect to his weight issues and had developed a plan for Charlie with respect to his weight loss. Those things are important if you're going to make a determination that a child has been tortured and that part of your decision is based on the lack of food or excessive exercise. So now it takes us to the basement. In order for me to find that the defendants tortured this child, I must find that there was a forcible restriction of his movement or forcible confinement of his, where he could not move about, or they were interfering with his ability to move about. The court cannot find that, and here's why. First of all, I heard officer after officer get on this stand and testify that they searched the house. There was a missing child that had been reported, and they searched the house. Not only did they search the house, specifically, they searched the basement. Not only did they specifically search the basement, but they did it on more than one occasion. There were officers that testified that there were dogs that were brought out to this scene. Dogs who never detected Charlie. Now, it's very important to understand that the cadaver dog did pick up a scent of Charlie in the back of the car that was driven by Mr. Bothuell and in a dumpster, and I believe there was another hit. However, there was some testimony given that the cadaver dog would pick up his scent if he was alive. It's for decomposition of the body. But Charlie is still alive. He really did show up and testify here at the preliminary examination. And so in order for the court to find that this child was forcibly confined to a basement, not given food, but then given food, that he was forcibly confined to a basement, that he heard his father looking for him, saw his father looking for him. He testified that his father didn't put him in the basement, yet he never yelled out, yet he never stood up, yet he never made himself known. I just don't believe him. I don't believe that he was in that basement, and as a part of the preliminary examination, I am required to assess credibility. It doesn't get to the finder of fact if I find the witness to be wholly incredible, which is what I found this witness to be with respect to his confinement in that basement. I don't believe that he was there 10 days. I don't believe that they restricted his movement. I don't believe that the police were there and they did this thorough investigation. The FBI, the evidence recovery team, the trace team, the dogs, and nobody found little Charlie in the basement of his home. I just cannot believe it. And so, based on those reasons, I am finding that the people have not met their verdict. With respect to count 1, I am dismissing count 1 as to torture. With respect to count 2, in the photos, and that is not reasonable force. It is not reasonable to discipline a child in that manner. And so I am going to find that the people have met their burden with respect to count 2, child abuse in the second degree, as to both of the defendants. That is the court's holding. Anything else on behalf of the people?
No, Your Honor, thank you.
Anything else on behalf of defendant Mr. Charlie Bothuell?
Yes, Judge. Where's the note for your... Judge, in light of the fact that the life offense is now set aside, can Mr. Bothuell have the tether taken off? It's extremely expensive. He's been wearing that for a long time now, and,
Let me have the people respond.
yeah.
I will leave it to the court. I really,
Okay, thank you. Then I'm going to reduce the bond to a $50,000 personal bond and remove the tether.
And then one for both defendants, Judge?
And are you making the same?
Yeah, I'm going to join on that, yeah.
Do you have a response as to Ms. Bowles?
no.
Thank you. Then I'm going to also make her bond $50,000 personal and remove the GPS tether. Anything else for the court's consideration?
Judge, the family court has put on hold their decision on whether or not Mr. Bothuell can see his kids, his biological
Then you're
children.
going to go back to the family court. I'm not making a ruling on that.
They were-
I
okay.
have no authority to
Well,
make.
they won't do anything unless you do something, that's what I'm saying. So there's a restriction in the bond and you have that says he can't see his biological
I
kids.
just reduced the bond.
Okay,
The bond is
thank you.
only going to be $50,000 personal bond, and I'm removing all other restrictions,
Okay.
all other bond provisions.
Okay.
Okay.
Thank you. Please
Thanks.
prepare
Thank you,
the
Judge.
appropriate bond
Thank you.
orders
Okay.
and the dismissal for my signature. I'm ready to call my next case. Not in my courtroom.
Hey, John. Hey, John.
Good job.
Hey folks, court in session, please move it over to the hallway. There's another case coming up.